So, dear participants, I would like to welcome all of you on behalf of our GoDape project group to our workshop on legal aspect of digital IP protection and management. The digital age comes with very exciting opportunity, interconnection at multiple levels through data sharing, cloud solution, embedded software into smart product, and so on. But it raises also new questions and challenges concerning data-driven innovation, legal data IP protection, and data ownership. In the EU-funded project GoDape, we address these challenges by raising awareness of digital data and software IP value. And we hope to positively impact IP management to up to 100 manufacturing SMEs in 3 Alpine innovation systems. GoDape bring together 3 local innovation agencies to jointly collect digital IP best practices, to propose scenario-based template contracts and model of data ownership. The project is led by Joseph Stefan Institute in Slovenia and include Hub Innovazione Trentino in Italia, as well as our own platform for innovation and technology, INNOSQUARE in Switzerland. Today's workshop is the second in a series of 3. Last Friday, many of us met to deal specifically with digital IP and data agreements. Best practices and guidelines for digital IP agreements were presented. And the question asked by the participant led to very productive discussion with our expert. The last workshop is scheduled on December 7, and we shed further light on the theme of data innovation and exploitation. I invite you to participate. I wish you an excellent workshop and look forward to upcoming discussion. Now, I give the floor to my colleague, Michael Keller, who is the moderator of this workshop. I thank him for it.
Yes, thank you very much, Pascal. Very warm welcome also from my side. I will also share my screen for a very, very short introduction. It's a pleasure to welcome all of you here on a very cold Friday afternoon in Switzerland, at least. I don't know what the weather looks like in the other countries. We have quite an international group here with partners from Italy and Slovenia. So thank you very much for all your interest this afternoon in this workshop on legal aspects of digital IP protection and management. I don't want to spend a lot of time because we have a very packed and dense agenda in the afternoon, and this whole workshop is actually not about us, of course, but about what we have to offer to you interested in this topic. And the first thing that I would shed some light on is the fact that we are extremely happy to welcome today a panel of distinguished experts in the field. We do have Ms. Fragnière, who is a lawyer at Kasser, Schlosser, avocat, with her expertise tonight, this afternoon on our panel. Maud is specialized in intellectual property, competition and contract law. We also have with us as an expert this afternoon to answer your questions and share her expertise with you, Ms. Talia Bally from the World Intellectual Property Organization. Talia is also a lawyer. She's an IP policy expert at the World Intellectual Property Organization. And she will this afternoon, and I'm really looking forward to this, present to all of us the brand new World Intellectual Property Organization IP Diagnostics tool. We have, last but not least, also Mr. Ivo Emanuilov from the Center for IT and IP Law at KU Leuven with us on the panel of experts to go through this afternoon's program with us as an expert. Ivo is an interdisciplinary researcher with broad interests in the field of computer science and law. And this combination certainly is the right type of profile to step in at the end of this workshop, as you will see, to give us some farewell recommendations. So we have this very distinguished panel of experts who will be with us this afternoon to address questions, some of the issues raised by Pascal in his introduction, but that's not all. We're actually also extremely happy to welcome, in addition to these experts, a set of companies. We will have Swiss Statistical Design and Innovation, Hieronymus, Translations by Lawyers for Lawyers. We will have the company CertX and ROOMZ. The companies will have time to introduce themselves later on in the process. And this is a bit the idea of this whole workshop. We would like this to be as interactive as possible. We actually want to confront our panel of experts with the perspective of the companies themselves, with the challenges that these companies in their daily business with data sharing, digital issues face, and try to address their questions with the help of our experts. And the way we're going to organize this afternoon is as follows. After this short introduction, we will directly give the floor to Ms. Fragnière for the keynote speech on legal aspects of digital IP protection and management, to give some introduction and the basis for the rest of the discussion in the afternoon. We will then give the floor to our companies to share their perspective, raise the issues that they have, that they would like to discuss with experts, the challenges that they face in their daily business. And we will then have an interactive session where the companies meet the experts, so to say. We will start this with a presentation of this brand new IP diagnostics tool. We will apply that to the cases of the presented companies to see how this tool can help to overcome some of the challenges, to answer some of the questions that we might hear of in the afternoon. And Ms. Fragnière will also be available to share her expertise and give advice on some of the issues that we collect during the afternoon. At the end, as I said, Mr. Emanuilov volunteered kindly to try to make sense of all of this with some farewell recommendations based on what he has heard during the afternoon and for future action. One preliminary remark before we start this dense program: we also have an ongoing questionnaire for companies where we collect issues and challenges, opinions, perspectives on these issues. I will not share results now. If you're interested, you can get in touch with me. We will, as soon as we have the final results from this survey, share that with all our stakeholders, of course, but you're more than welcome to participate in this questionnaire as well. Therefore, I have integrated here the QR code that you can use to access this questionnaire, and we would be happy if we can get your perspectives and answers on these questions as well. And as I have said, we would really like this afternoon to be interactive. We will have, in the end, after the presentations, a full hour where we have the time to discover the IP diagnostics tool, to discuss it, but also to discuss the questions that might arise during the workshop that you might have for our experts. So feel free to use the chat for questions whenever you want. I will keep an eye on it and track these questions so that we can hand them over to the panel of experts in the interactive part. And in the interactive part, you can, of course, also just raise your hand and take the floor if you have questions for our experts. All right, this being said, I don't want to take more time because now it's time for our experts and then for the companies. So I will directly give the floor to Maud Fragnière for her keynote. And thank you very much for your availability to share your expertise with us. Maud, the floor is yours.
Thank you, Michael. Good afternoon, everyone. I'm very happy to have the opportunity this afternoon to present to you some legal aspects regarding digital IP and data management. So to begin with, I would like to draw your attention on the fact that there basically is no protection in the absence of an intellectual property right, which means that at least in Switzerland, there is an absolute freedom to imitate. What does this mean? It has downsides, obviously, this freedom to imitate, but also advantages. This means that once you have protected something, a right is in your company with an IP right, then you have a monopoly on this right, pursuant to certain conditions I will discuss further in this presentation. But also, when you have a project, you should always ensure that you are not infringing any third party intellectual property, in relation with the field of business. When we say IP, what do we mean? What does IP basically cover? So we have trademarks, such for example as the Coca trademark of the Swiss company. You have designs, which, for example, could be registered for a graphical interface of an application. Then you have patents, which could, for example, be registered for a method and device for identifying a data packet in a data stream. You would then have copyright, say for source code, and finally trade secrets, which could include, for example, all your clients' data. The three first IP rights I have mentioned, trademarks, design, and patents, are registrable, which means they are protected only once they have been registered, filed, whereas the two last, copyright and trade secrets, are not registrable, which means they are protected per se. Obviously, you need to take certain cautions. I will get to that later. Regarding trademarks, for example, so this Coca trademark of the eponym Swiss company, it gives you a monopoly on a defined territory where you have filed that trademark, obviously only on the brand, on the trademark, and not on the technology that is behind that. I wanted to draw your attention on one thing that the companies often are unaware of, is that you need to register your, your trademark as you have registered it. So for example, here, if you have registered the Coca trademark in pink with a specific graphism, if you use it plainly black and white on the market, it would not be considered as a sufficient use of your trademark. Why do I draw your attention on this? It is because if for 5 years in a row you do not use your trademark as you had registered it, then you would lose all protection. The approximate costs for registering a trademark in Switzerland are 1,500 francs. That grants you a protection for 10 years, and then obviously you can extend it indefinitely for 700 francs each time for 10 years protection. I just wanted to mention the provisions that apply. Supposedly, if you once find yourself needing to enforce your trademarks, there are civil and criminal provisions that apply, but I will not go through them. It's just for you to have them on record. The further IP right is, as I had mentioned, design. So potentially you could register it for your graphical interface of an application. It also grants you a monopoly on a defined territory where supposedly you have registered your design. However, in order to register a design, it needs to be new and original. What we mean by new is that simply it should not already be on the market, but original, it should distinguish itself sufficiently from the designs that are already available on the market, not specifically in your field of business, but generally available on the market. One thing that you must be aware of if you plan to register a design, once you have publicly disclosed a design, you only have 12 months to register it. So if you think that there is a possibility to register a design on one of your products, you should act quite quickly once you have disclosed it in order not to lose the right to a design. The approximate cost for you to know to register a design in Switzerland is 2,000 francs. This grants you a 5 years protection and is indefinitely extendable. The extension costs between 200 and 700 francs. That depends on the number of graphisms that you wish to register. Here again, you have civil and criminal enforcement possibilities. Coming now to patents, I mentioned this Article 1 of Federal Patents Act. It's because it's very important in the technology field. So the patents can be delivered only for new inventions applicable in industry. Why do I say that? It's because computational models or mathematical algorithms per se are not patentable because they are of abstract nature. It's only if they are used to solve a technical problem in the technology field that they can lead to a patent. I give you here an example. So the use of a neural network in a heart monitoring apparatus for the purpose of identifying irregular heartbeats, then this neural network could be the object of a patent. The same, the classification of digital videos based on low-level features such as pixels could also be the object of a patent. A patent grants you obviously a monopoly on a defined territory. However, generally for 20 years max, as is the case in Switzerland. Why do I mention this? Is because sometimes for a company, it could actually be in their best interest not to register a patent, because once you register it, you disclose very much information on your technology. And of course, you have this 20 years monopoly, but potentially if you kept your technology as trade secrets, you can imagine keeping protection for much more than 20 years if you're able to enforce correctly your trade secrets. And why not benefit of this monopoly for 40 to 50 years? However, patents are of particular interest in the framework of financing rounds, notably for startups, which obviously is always something to keep in mind since the patents are usually valued quite high when there are financing rounds for startups. In order to register a patent, it needs to be new and to show inventive step. What does this mean? So new, obviously, it must not exist as such on the market, but to have inventive step is mean that an engineer specialized in your field of business, on the basis of the information already at hand in this field of business, he should not find evident your invention. So your invention should show some kind of ingenuity in relation as to what already exists on the market. The approximate cost in Switzerland for a patent are 5,000 francs. And as I said, it's for 20 years protection. There again, you have civil and criminal enforcement for patent infringement. Coming now to non-registrable IP rights. So first, copyright, which hypothetically would apply to your code or your algorithm. What you need to keep in mind is that copyright only protects you against copies of your IP right, of your algorithm or your code, which means that, say, a competitor who would inspire himself of your algorithms, should he have had access to that, and who would modify sufficiently this algorithm, he would not be committing an infringement of your copyright. However, it is always worth putting this signal that is on the bottom of the screen, so this copyright signal, in order to mention and to draw attention of your partners or employees on the fact that you consider some specific work, algorithm, code, document, or whatever as confidential information protected by copyright. It also enables you, by hypothesis, in case of an infringement, to seek damages before a court. When you want to enforce copyright, you have to prove that you were the first on the market, that you were the first to have created that copyright. For that, of course, a simple email to yourself would suffice here in Switzerland. However, the WIPO has a very useful tool, which is WIPO Proof, which provides a date and time-stamped digital fingerprint on any file, and which globally, worldwide, knowing that in several countries the evidence is much stricter than in Switzerland, provides a good evidence of the fact that you were first to create specific work. Copyright is also quite important in relation with NFTs. You have probably already all heard of these non-fungible tokens, which use blockchain technology in order to prove the authenticity of a defined work. If you deem that one, say, of your work would be sufficiently, the copyright related to one of your specific words is quite important, you could consider having an NFT prove the authenticity of such work of yours. There again, you have civil and criminal enforcement for copyright infringements. And now I'm coming to trade secrets. Trade secrets is very important because, as I've just said, much of your IP isn't protected by registrations. This is a case of all your data, all your algorithms. This is why you need absolutely to protect as actively as possible your trade secrets, which, by the way, also includes all your know-how. How do you do that? There are best practices that you should have in mind, is to identify very clearly in your company all the information that is confidential. And by identifying, I mean by specifically mentioning wherever possible that such information you consider confidential. You should also take all necessary measures to ensure that confidential, because this will be very important if once you want to enforce your trade secrets. So you need to limit access to the confidential information, not only within your company, which means only the employees who need to have access to confidential information actually have access, but also any of your partners, suppliers, whatever. There, again, in your contracts with these third parties, you need to have a specific determination of who can have access to the confidential information, and that they actually access to that information only to perform the necessary tasks. You should also know that there are technical measures that can be put in place to ensure confidentiality, such as software which actually detects each access that is being made to data and by whom. And then once you have done all that, you should, of course, take the basic measure, which are non-disclosure agreements, not only with your employees, but also with third parties. When it is with third parties, always have penalties in your NDAs. Why? It is because, let's say the third party violates this confidentiality obligation. You would have before a court to prove the extent of the damage, to prove the amount that this infringement represents for your company. And this is always very, very difficult, which is why seeking actual damages without penalty is very difficult in Switzerland. Whereas if you have a penalty in your NDA agreement, then you can just seek that compensation that is provided for in your agreement without having to prove anything particular other than the actual infringement. You could always also think of non-compete clauses, say if not only again with your employees, but with say your suppliers, which for example, if you hand to your supplier quite important proprietary data that you have, you could provide for that for the next 3 to 5 years, that supplier would not be available to work with another company active in your field of business. Obviously, you need to be very careful with the wording of non-compete clauses for them to be valid, because since they restrict the economic freedom of your partner, it has to be reasonable enough. Reason why I was mentioning 3 to 5 years, you cannot, for example, have 30 years non-compete clause. It would obviously be null. There again, I wanted just to mention them to you in case you once needed. There are civil and criminal enforcement for trade secrets, in particular under the Unfair Competition Act. When you transfer IP rights, it is very important that you choose the right wording in your contracts. This is because digital IP, as for now, is not much regulated, as we have just seen. So it will basically be your contracts with your partners, which will define what rights you keep, what rights you are transferring, what this partner will be able to do with your data or with your code, and what you will be further allowed to do with your data. So this is of particular interest when you have IT contracts. When you sign IT contracts, if you have an IT supplier, you provide him data upon which he will build software. You don't want him to be further using your data or to be reusing the software he has built for you, say for a competitor. The same applies for data transfer. So if you sell data to a company, you want to know what this company will do with your data. Will that company act in your field of business or in a field of business close to yours? Who owns the data? What you will still be able to do with it, etc. So of course, it's very general for me to say choose the right wording, but I cannot give you more specific details as it would depend obviously on the concrete case. However, always keep in mind you need to know exactly what rights you will keep, what rights you need to keep, and to what extent are you giving rights to your partner. When we talk about data, I also need to talk to you about data management, because obviously it's getting more and more important nowadays because of the data protection rules generally applicable. First of all, what is personal data? That is any information that can be used to identify a living person or that relates to them. This means their name, health information, online identifiers, location, etc. As of today, there is generally the GDPR rules, so the General Data Protection Regulation that is applicable. This regulation is basically only applicable if users residing in the European Union are concerned. However, today it is almost never the case that only users residing in Switzerland are concerned. And anyway, the data protection rules in Switzerland are changing, and soon it will probably be approximately the same rules that apply today in the European Union that will be applicable in Switzerland. Reason why we always recommend to our clients as from now to implement the GDPR rules. What are those rules? It's first of all that the general legal basis for processing data is you need the user's consent, or you need to have legitimate interest. However, legitimate interests do not rely on this criteria, since basically it would only need to perform a specific task. So if I send you data because I want you to, because I want you to build me a software based on my data, you would be allowed to do that. However, generally, it is always much broader than that you transfer data. Reason why rely upon the fact that you need to have the user's consent. In order to gain such consent, you cannot have just a pre-ticked box when one lands on your website. It needs to be explicit. Reason why the boxes must be void, and the user must specifically tick the specific box. He also always needs to have opt-out, unsubscribe possibilities, as you probably know, but I wanted to remind it to you. And please always be careful. The users need to have at all times the possibility to have their data deleted and to have access to their files. What does that mean for you? Is that at any point in time, you must be available without delay to get to a person's specific information and hand it over to him quite quickly. The key elements in data management are the privacy policies, which disclose the way the data is used and managed. You need to have one. the cookies policy, obviously, which discloses what cookies are active on your website. And finally, the localization of servers, generally called safe harbor. Basically, it means that you should not have any data stored or processed in servers in the US, but you should have them here in Europe. Finally, in order to implement the GDPR, and in case your core activities involve processing of sensitive data on a large scale, or involve large-scale, regular, and systematic monitoring of individuals, which is almost always the case if you need to process your users' data in order to pursue your business, then you need to appoint a data protection officer. This doesn't need to be someone in your firm. It can be someone on the outside that would have that would be specialized in the field of data protection. And then you would need to have processes. Processes is you need to define which data is concerned in your company by data protection. You need to have processes to detect a potential breach and to manage them. Obviously, if you have a DPO, the only management of data breach that you would need to have is to notify the DPO about the data breach, and then he will take over and notify the relevant authorities. Okay. Thank you very much for your attention, and I'd be very happy to answer to any questions you might have.
Thank you, Maud, for this great first inputs and overview. There has been a comment in the chat on blockchain, but I think we will be able to pick that up later. All the questions that you might have from the participant side, also the companies who might maybe have questions now to what you have heard from Maud Fragnière, you can use the chat. We will put everything on our documents and try to address all of this in the interactive part towards the end of the workshop. I would like to take over the screen again to continue the agenda of the afternoon. Thank you very much, Ms. Fragnière. We will have the opportunity to discuss the questions that will arise later on, as we have said. Let me just get back.
Well, I would have a question, if that's okay now, or you want to discuss the questions later?
We actually would. I would prefer to have the questions later centralized.
Okay. Okay.
If you want to submit it in the chat.
No, this is fine. Yeah.
Okay, you can also add it in the chat, then we directly have it, and we can actually prepare it then for the interactive session. But I would like to give the floor to the companies now, because some of them will have to leave us, and all of them have shown great interest to actually also be able to see how this brand new IP diagnostics tool, the WIPO diagnostics tool, works. So if we can move on with that, that would be perfect, and we will collect your questions for later on. I will not forget you. All right, so we would like to give the floor now to the companies to confront a bit what we have heard with a practical side, to see how all of this looks like through the eyes of entrepreneurs. We have a panel here of 4 Swiss companies, Paula Reichenberg, CEO of Hieronymus, Roger Meier, CEO of ROOMZ, Jens Henkner, the CEO of CertX, and Xavier, who is the co-founder of Swiss-SDI. I will give the floor to all of these companies in turn. They will present themselves briefly and illustrate what type of digital IP challenges they face, what type of solutions they may be found, and what open questions they have to the experts, and we will then discuss this all together. So without any further ado, I will give the floor to Paula Reichenberg. Please, the floor is yours. Great, yeah, thanks, Talia. It really shows how powerful this tool is, and I can just repeat that we invite, of course, all the participants to try it out yourself and give feedback and see how it can help you. I understood that Jens does not have a follow-up question. Then I will just briefly show my screen again to see what I have collected in addition to this. And there are two questions that I would very briefly like to give before we conclude with our third expert to Maud, because you mentioned that you actually have an answer on this. There was one question on penalties in non-disclosure agreements with the problem that they're very difficult to negotiate with partners. And the question, would injunctive relief be a better option on this? And I know that you have an answer on this. And then there's also a question on trustworthiness in digital data protection and how contracts can actually address this. And the third question I would keep for later on, but maybe if you have short advice on these two questions before we conclude.
Yes, so as I said before, you should first really try and negotiate penalties. However, if you do not succeed, yes, of course you can initiate injunctive proceedings. However, I think you know that it's quite expensive. We talk about civil proceedings. For example, in patent matters, injunctive relief would cost about 40,000 to 50,000 in total when you count patent counsel costs, lawyer costs, and court costs. So, of course, there is this possibility. Of course, if you have no other choice, you will undertake such an action, but you must be aware of the related costs. As regards the next question, the trustworthiness of digital data protection, there are assessments that can be made. I believe KPMG, for example, and the other big four undertake such assessments, and then they grant you a statement on the level of trustworthiness of your data protection in your company or in, say, your suppliers, for a supplier for you to work with. And you can ask for such assessments. What kind of risks, mitigating points? So how can you address this in contracts? There is almost no way to really rule out liability. So as we've said many times today, it's really the clauses you take. So you should, for example, have your supplier represent that he will not work with subcontractors. You can, for example, have him hold you harmless, but of course, then if he goes into bankruptcy, this will not help you very much. You could have guarantees in form of bank credits, for example, if it is really, really delicate matters that will be undertaken with that company. That is some ideas that I could think of just now on the spot.
Thank you very much, Maud and Talia, for all of this. We will certainly have the opportunity to interact also after the workshop, but I would now like to introduce to you our third expert, Ivo Emanuilov, from the Center for IT and IP Law at KU Leuven, an interdisciplinary researcher. And we gave you the very complicated and difficult task to try to make sense of all of this that we have heard. There is this third question out there that really triggers me as well. We have discussed a little bit about this. Data is publicly available out there. Are we simply free to use it? It sounded to me like a question that I wanted to hand over to you and then give you the opportunity to try to make sense of all the rest that you have heard, and if possible, give us and the companies and innovation agencies that are following this some useful recommendation for our weekend and for the future of our IP and digital IP issues.
Thank you, Michael, and hello everyone. Good afternoon. Thanks for staying up so late in the Friday afternoon. And indeed, I have the uneasy task to try to make sense of what has been said. And as a researcher, standing at the interface of law and computer science, I have to say that we hardly have a definitive answer to any of the questions that we raised today. Some of them, yes, but definitely not all of them. To go directly to that question, and then I'll continue with some points that I've noted down. Just because data is publicly available does not mean that we can freely use it. And that's because data is not a single entity that has a uniform characteristics. You know, we discussed personal data, we discussed industrial data. These are different categories of data that are governed by different rules of the law. So if you are processing data concerning an identified or identified viable individual, then you need to comply with the requirements for processing of such data imposed by data protection law. So there is no other way but to find a lawful ground upon which to process such data, and you need to make sure that you can process these data on a specific purpose in line with all principles listed under Article 5 of GDPR. And that's just one example concerning personal data. For text and data mining, we have the exception under Article 3 and 4.3 for scientific, for non-scientific uses under the new copyright in the Digital Single Market Directive. But then the directive itself, the provision of Article 4 says that you can do text and data mining so long as the works are lawfully accessible. So that means you cannot just take data from a source without having the right to do so, and just transform it into your model and make sense of it. So in this sense, just because something is available on the internet doesn't mean that you can merely take it. And I teach this to fellow computer scientists. And I have to tell you that it's very hard a concept for them to get sometimes, that you cannot just go and grab something that's freely available. But unfortunately, or fortunately, that seems to be the case. Of course, we have a lot of public data which are available under permissive licenses. So that means that you can actually take it and use it. And if you look at commercial models such as GPT-3, for example, or BERT and so on, lots of them have been trained on permissively licensed data sets. And Wikipedia is one such huge source for training data. And with that, I'd like to move to some of the points that I've jotted down from today's discussion in an attempt to summarize and also give some further food for thought from what we heard today. As a general recommendation, I would definitely say that every business model should be matched with a specific IP strategy. So there is no one size fits all. And in this sense, the business model, the needs of your business model, whether it's data-driven, data-intensive or not, will also determine what rights you will need to protect in the process. For business models that are data-intensive and that are actually the predominant case nowadays, you should always consider your data sources and implement data governance strategies. In this sense, we need to always ask the questions, are data transactions actually provision of a product or supply of a service? Because that would could determine different conditions in the contracts that you execute, whether we are talking about a product or a service, and a product has specific definition in European law, for instance. Secondly, how do we transact with more complex data products? So, for example, models that are increasingly used in transfer learning or digital twin simulations, which, as of recently, since the decision of the enlarged Board of Appeals of the European Patent Office, we now know that computer simulations, which do not necessarily always exert physical effects, can still be protected as patentable subject matter. This is a very important decision that will have a huge impact in the field of specifically industrial digital twin simulations, for example. Also, we can find some guidance for complex subject matter in the Nintendo case law of the Court of Justice, for example, where a video game was discussed as such complex subject matter. So we have some pointers here and there, but we don't have the full picture. And we also have the example of Lex Machina's neuro-machine translation. So, for example, if we take that model, should we qualify it as software, as data, as database, or as all three of them under intellectual property law? Because, you know, in computer science and in law, certain terms could have very different meaning, and it's very important to understand why the law treats certain concept differently than its technical meaning. I already mentioned the public data aspect, I would say that licenses are critical here, but we also need to make sure that the licenses of the inbound data are compatible with each other, and that's a problem that has not been studied that much in the field of open data specifically. It has been extensively studied in the field of open source software compatibility, inbound and outbound compatibility of licenses, but not so much in the field of open data, and I think it's an important point that needs to be considered. Also, I mentioned the text and data mining exception that we have under the copyright in the Digital Single Market Directive. Don't forget, again, the main points: works must be lawfully accessible, reproductions and extractions must be retained only for so long as necessary for the purpose of text and data mining. And that's something, a criterion that we will need to quantify somehow and make sense of it as practice under this article accumulates with time. Furthermore, don't forget that the third paragraph of this provision actually mentions that the text and data mining exceptions only applies to the extent that the use of works has not been reserved by rights holders. And we need to understand and analyze what this reservation, what form could it take? Could an author make a reservation by means of a contractual provision, for example, and whether the data licenses you work with do not somehow contain such implicit or explicit reservations? It's a question that was recently raised in the field of Creative Commons licenses, particularly the non-commercial and non-derivative clauses, whether these clauses could somehow be considered as a reservation under paragraph 3. We also need to consider the interaction of IP rights with other considerations such as bias mitigation and automated classification and filtering that may impact access to the works. And we have one very interesting example, for instance, with the parody exception that we have under European copyright law. For instance, if we apply that exception to a model that has been trained in US, predominantly with the US understanding culturally and legally of what a parody means, would the same model applied in a European context not render results that would ultimately restrict access to the works? And I'm, of course, talking here about the provision of Article 17 of the Copyright Directive. Third question is the protection of algorithm that is sold to customers. That was raised already, and colleagues already discussed upon it with food modification rights. But I would like to raise a couple of preliminary questions here, which is, what is actually the algorithm we are talking about? And in machine learning, typically an algorithm has two senses. So one is the system software that makes predictions based on input data. We generally call these predictors. And the second is system software that adapts some internal parameters of the predictor so that it performs well on future unseen data. And we call this the training of a system. So we need to make sense of different technical understanding of the meaning of algorithm and also related phenomena such as models to distinguish these legally and to find out where they belong systematically, in which category of the law as it stands now. Furthermore, the value, at least in deep learning application, lies in the neural net weights. And the problem here is whether the model itself then should merely be seen as a database. However, we saw also in the questions that were raised that the database directive itself offers two types of protection. So one is copyright protection to the extent that the database meets the originality criterion of being an author's own intellectual creation. And on the other hand, the sui generis right, which protects the investment of the database maker. But don't forget the database rights do not protect the underlying data as such. And the question of whether a neural net weights could be protected under the database directive is something that needs further exploration. It's a question that practices and businesses will often face. As to the question of how we can actually restrict access to our models, well, if you think of how most commercially relevant models are being distributed currently and will probably be distributed in the future, it's very likely that this will be by means of restricted public-facing application programming interfaces. So that means you basically interact with the model, but you don't see the model itself. You don't have access to it. So you submit your query, you get out the result of the model, but you never see the actual model. And therefore, from a commercial perspective, from the perspective of a company, that model never sees, the customer never sees your model and what went into it. Concerning sharing code to clients, I think colleagues covered it very well. Non-disclosure agreements are indeed the only way. Then the question of enforcement is always a tricky one, but it is what it is. I mean, the NDA is the legal vehicle that should be used in such cases. For AI based on customer data, data licenses I mentioned are very important, but they're not enough because clearing access and processing rights over personal data requires that we also meet the obligations under data protection law. And also concerning the problem of transformation of data. So when we take a data set which goes into the machine learning model, what happens there is that sometimes, you know, it's actually an effect, it's not a defect of machine learning, that machine learning models tend to overfit. What does that mean? Well, they basically memorize parts of the data sets. And as the neural network training minimizes loss across all examples that it's being faced, training necessarily involves a form of memorization. And much work has been done to mitigate this effect, but not necessarily. Furthermore, we also have the related phenomena that has recently been studied in DeepMind of unintended memorization, which means that basically sometimes the model memorizes parts of the input data set which are not really necessary for the task at hand and which unfortunately could later on be reproduced verbatim. And from a copyright perspective, that could be something. And because I'm way over time, I will just finish with one last thing, because I heard reverse engineering being mentioned here, and I think this is a very important element that everyone doing interfacing somehow, working with artificial intelligence should keep in mind, because as Bruce Meier and other researchers have argued in a very interesting study on the legal status of adversarial machine learning, well, they said basically that the more complex machine learning models become, the more likely it is that the only way to understand them and to make sense of them would be to actually reverse engineering, to look inside the black box and to try to uncover what is going on. But as you can imagine, there are limitations to this that come not only from, of course, cybersecurity and criminal law, but also limitations that might originate in copyright law, for example. And I would just invite future work on the question of how the decompilation exception that we have in the Computer Programs Directive would apply to reverse engineering of a machine learning model. I argue that it's not going to be precisely the same. I don't know what it's going to be, but it's certainly a question that merits further discussion. So sorry for taking more than I was allocated, and it's been a pleasure to be part of today's event.
Thank you so much, Ivo. Wow, great conclusions here with some questions for the future. Yeah, the future is what is next now, basically. And I can promise you that we will certainly have the opportunity to interact during the rest of our project, to make use and benefit from the contacts that we could make through this workshop this afternoon to hopefully answer more of these questions. I do hope that the afternoon was already useful for many of you in answering specific questions. For me, it was extremely interesting, I have to say, to discover so many interesting companies, their digital IP issues, the answers that our experts gave on all of this. I hope it was useful for all of you as well. Before we close, we're almost on time. I would like to let you know that you can give feedback also As I told you, it was very interesting for me to learn so much from our great experts. I do hope that you enjoyed the afternoon as well, even if it's late on a Friday afternoon. If you did like it, let us know on the forum. If you did not like it, if you have recommendation for the future, make sure to also leave a note in the survey, and we'll try our best to make it better the next time. And the next time will be very soon, actually. So as has been said by Pascal at the beginning of this workshop, there will be a third workshop really focusing on data-driven innovation and exploitation. It will be on December 7th, organized by Joseph Stefan Institute. It will be again, it's a Tuesday this time, not a Friday. It will be again at 2:30 p.m. and we hope that we will see many of you again on December 7th.